And we'd like to start by thanking the UN Special Rapporteur on Toxics and Human Rights for bringing us together this afternoon, to reflect on his latest thematic report to the Human Rights Council entitled Guidelines on Access to Justice and Effective Remedies in the Context of Toxics, that he will be presenting this week to the Council. This side event to the ongoing session of the Human Rights Council is organized by the UN Special Rapporteur and co-sponsored by Côte d'Ivoire and the Geneva Network. To formally welcome you to this event, we have the pleasure to give the floor to the Chargée d'Affaires of the Primary Mission of Côte d'Ivoire to the United Nations in Geneva, Mrs. Roselyne Kanga. Ms. Kanga will speak in French, and in accordance with the rules of multilingualism governing multilateralism, her speech has been translated to English and is available for distribution. So the colleagues have been distributing it in the room. So without further ado, Madame Kanga, vous avez la parole.
Okay. Thank you very much. Merci beaucoup. Monsieur le rapporteur spécial, Mesdames et Messieurs les représentants des missions diplomatiques, des organisations internationales, de la société civile et du monde académique, distingués participants, je voudrais avant tout propos exprimer les remerciements de la Côte d'Ivoire au rapporteur spécial Dr Marcos Orellana pour l'organisation de cet événement parallèle consacré à une question qui touche au cœur même de la dignité humaine, l'accès à la justice et à des recours effectifs pour les victimes de substances et déchets dangereux. En tant que porte-plume de la résolution sur les déchets toxiques au Conseil des droits de l'homme, mon pays connaît et comprend la douleur que peuvent engendrer les déchets dangereux. L'affaire du Probo Koala en 2006 demeure une blessure profonde dans notre mémoire nationale. Ce déversement aux conséquences sanitaires et environnementales désastreuses a rappelé avec brutalité les ravages de l'impunité et les obstacles qui entravent encore trop souvent l'accès des victimes à la justice. Malheureusement, ce drame n'est pas isolé. Partout dans le monde, des communautés subsistent des atteintes similaires. Trop souvent, ils sont confrontés à des charges de preuves écrasantes, à des délais de prescription inadaptés ou à des coûts prohibitifs. Ces barrières nourrissent l'injustice, aggravent la souffrance et sapent la confiance de nos institutions. Face à cette réalité, le rapport thématique présenté par le rapporteur spécial, assorti de lignes directrices, constitue une avancée majeure. Ces recommandations offrent aux États des repères précieux pour renforcer la responsabilité, combattre l'impunité et garantir la pleine effectivité des droits fondamentaux, à savoir le droit à la vie, à la santé et à un environnement propre, sain et durable. Nous saluons l'initiative de cet événement qui sera l'occasion de partager des expériences, d'identifier des solutions concrètes pour lever les obstacles à l'accès à la justice et d'explorer les moyens de mettre en œuvre les recommandations du rapporteur spécial. Distingués participants, la lutte contre les déchets toxiques est, par essence, un combat collectif. Elle requiert l'action résolue des États, l'appui des organisations internationales, l'engagement de la société civile et l'expertise du monde académique. Ce n'est qu'ensemble que nous pouvons rendre justice aux victimes et prévenir la répétition de telles tragédies. En réaffirmant la détermination de la Côte d'Ivoire à poursuivre ce plaidoyer, tant au Conseil des droits de l'homme qu'au-delà, je souhaite des échanges constructifs et porteurs de solutions avec nos éminents panélistes. Je vous remercie.
Merci, thank you, Ms. Kanga, for reminding us of the struggles your country and other regions face or face in regards to toxics, the importance of the mandate of the Special Rapporteur and of his new thematic report, identifying concrete solutions to remove obstacles to access to justice. We'll now turn to the UN Special Rapporteur on Toxics and Human Rights, Mr. Marcos Orellana, who will provide an overview of his new thematic report to the Council, putting forward 24 guidelines on access to justice and effective remedies in the context of toxics. Mr. Special Rapporteur, you have the floor.
Thank you very much, Diana. Excellencies, distinguished delegates, friends, good afternoon. This is my last report to the Human Rights Council, and I thought it would be fitting to focus on elaborating guidelines that could serve as tools to overcome what is a crisis of accountability in regards to the exposure that countless individuals, groups around the world suffer in connection with hazardous substances and wastes. It is by now well known that the planet is facing a triple planetary crisis of climate change, ecosystems, biodiversity loss, and toxic pollution. The impunity that victims of toxic pollution face aggravates the increasing toxification of our planet. For millions of people around the world, exposure to toxics means fear, anxiety, illness, disabilities, or a premature and painful death. And in the efforts at trying to secure remedies for such violations, there are numerous obstacles that stand on the way. In the report that I will present to the Council, perhaps this afternoon or tomorrow, has, in addition to 24 guidelines, 3 basic parts. One is an examination of human rights standards that concern access to justice and effective remedies. Because we're not starting from scratch. Human rights law already recognizes that access to justice and effective remedies is a cross-cutting and key pillar of the human rights framework. Remedies that should be adequate, timely, accessible, and enforceable make a cornerstone of the system. Let me give you a couple of examples of how this has unfolded in the jurisprudence of global and regional human rights monitoring mechanisms and courts. In the context of the International Covenant on Civil and Political Rights, the Human Rights Committee has decided the case of Portillo Cáceres versus Paraguay. And in addition to finding violations of the right to life, it has found that an effective remedy was not granted to the victims because the investigations were slow and did not lead to redress of harm. In cases decided by the European Court of Human Rights, as the cases involving asbestos exposure in Switzerland, the court has considered that a person that could not know about the harm that would result from the exposure could not be deprived from a remedy under a statute of limitations. So this was held to constitute a violation of the right to a fair trial. In the Americas, the American Court of Human Rights, the Inter-American Court of Human Rights, in a recent case of inhabitants of La Oroya versus Peru, the court, among its analysis of the right to health and the right to life and the right to a healthy environment, it analyzed the fact that the responding state had not implemented and complied with a constitutional court judgment for many years, and on that basis found a violation of the right to remedy. And the African Court on Human Rights and People's Rights, in the case of that was recalled by Her Excellency on the Provo Koala, the dumping by Trafigura, the multinational, of hazardous wastes in Cote d'Ivoire, found that while the African Charter on Human and People's Rights does not explicitly include a right to a remedy, it does that in cases involving the dumping of hazardous wastes, the Bamako Convention on hazardous waste, which was negotiated to prevent the import into Africa of hazardous waste generated outside the continent, further reinforce the right to remedies. So there is strong basis on access to justice and effective remedies when applied in the context of toxics. But there are a number of barriers and obstacles that create a gap and distance between the laws on the books and the standards established in international law and reality of victims and their families that suffer from exposure and toxic contamination. One of these barriers is inadequate laws. And in many parts of the world, environmental laws have evolved since at least the Stockholm Conference on the Human Environment in 1972. They have focused on minimizing and managing, but without a human rights-based approach. And where domestic laws are inadequate, the result is legalized poisoning of people, and human rights infringements follow from that. There are also other obstacles, and for the sake of time, I'll name a few. Limited standing. In a number of jurisdictions, standing to go to court, to access justice is limited to the specific victim that may have suffered a violation. And this, in the context of toxics, deprives civil society organizations, deprives communities from the ability to present collective actions in defense of diffuse interests that may be implicated in cases involving toxics. Here, I think it makes sense to pause and recognize a couple of features of toxics-related cases. One of them is the potentially long latency periods. And so from the moment that exposure takes place until there may be manifestation or onset of clinical symptoms, a long period may pass where there may be uncertainty as to whether people may get sick. And for people living in exposed areas, this means living in fear, with anxiety, anguish. Well, it is often the case that given this latency period, point about statute of limitations becomes an obstacle to effective remedies. It should also be said that in human rights law, the point that the rights that are elaborated and recognized in international treaties are not established for the benefit of contracting parties, but for the benefit of people under the jurisdiction of those contracting parties. And that means that, among other things, that there's a collective nature of these instruments, an erga omnes dimension, which translates in that the restorative function is not only for the benefit of the victims, but also for the deterrence in the benefit of society and the legal order that these treaties create. This has implications for remedies, because we're not talking just about compensation or cleanup. We're talking about a whole range of remedies that should be tailor-made for the situation in question that go well beyond those two essential components. Among other barriers, and I'm running out of time, are lack of information to prove cases. I mentioned about statute of limitations, difficulties in the burden of proof, the financial costs, undue delay, linguistic barriers, the misapplication of forum non-convenience, changes in corporate form and divestment. And the thematic report that I will present to the Human Rights Council elaborates with examples on all of this. But it's not only barriers, there's good practices, there's innovations that are tending to overcome these obstacles, such as in respect of evidence and the burden of proof. So, for example, in the recent case decided by the European Court of Human Rights in Cannavacciolo versus Italy, echoing what was done by the Inter-American Court of Human Rights in La Oroya versus Peru, the courts considered that a person that has been exposed to hazardous substances, and there's evidence of that exposure, need not prove a causal connection between any illness that may have been manifested in her body. So it's enough to prove the exposure and the hazardous characteristics of the substance. There's a lot that could be said about the application of the precautionary principle as an element of due diligence, expanded legal standing, transboundary justice, legacy pollution, specialized courts, tailored remedies, in order to, as it were, distill elements of good practice, the tools that can enable the strengthening of legal systems and judicial practices in the area of context. The report puts forward 24 guidelines for the consideration of the Council. I think I'm out of time, so I will stop there. Thank you very much, Diana, and thank you very much, all of you, for your attention.
Thank you very much, Mrs. Special Rapporteur. To reflect on the Special Rapporteur thematic report, messages and explore ways to implement the Special Rapporteur's recommendations and guidance, we are joined by a panel of leading experts. Our first speaker in the discussion is Mariana Bolshakova, a legal advisor with the United Nations Environment Program, who will be reflecting on the Special Rapporteur report from the lens of the UNEP Environment Rule of Law report issued in 2023, also in the margins of the Council. Mariana, you have.
Thank you, Dan, thank you, Marcos. It's really a pleasure to be here with you today at this event. We at UNEP very much welcome both the report of the Special Rapporteur and also the report's assessment, in particular the 24 guidelines that you have in there, which draw the attention of member states to issues that are really, really important for environmental law. As many of you know, UNEP has been supporting and promoting the environmental rule of law, both at national and international level for several decades now. We work very closely with UNHCR and promoting the recognition of important linkages between the environment and the enjoyment of human rights. In this regard, we're particularly proud of the work we jointly did that supported the recognition by the General Assembly of the right to healthy environment just a few years ago. Over the last several years, UNEP has developed a detailed assessment on the status and trends in environmental rule of law. This first report on environmental rule of law was published in 2019, and it was followed by an updated assessment in 2023. So this assessment in our report strongly supports many of the conclusions and many of the guidelines that you find in the Special Rapporteur's report. I could probably make linkages to all 24 guidelines, but given the time, I will address 3 or 4 of those. So the first one is the issue of standing. The other one is the guideline related to the enabling environment and the important role that defenders play in promoting effective access to justice by communities. And finally, the issue and the importance of specialized tribunals and training for the judiciary and the law enforcement officials. So on standing, which is addressed in guideline 6, we've established there's a growing number of countries that have specifically provided for open standing in environmental cases, which allows any legal person to bring an action to protect the environment, whether or not that person has been directly affected. On standing, the open standing can make it easier for environmental non-profits, for civil society groups. They're best placed to identify violations of environmental standards, to seek protection for the environment, or to seek remedies where damages have occurred. And as of 2021, we estimate that at least 45 states have adopted laws or procedures that provide for open standing in environmental cases specifically. In many instances, such provisions are part of framework environmental statutes. In some other cases, open standing is provided for in constitutions or established through judicial precedent or court procedures. In addition to those 45 countries that have developed open standing, many states have liberalized standing to allow a wider range of actors to bring claims. At least 24 such states have enacted laws or received judicial decisions that give NGOs special rights of standing in environmental cases, and they expanded the definition of who is concerned party or interested party in cases that address environmental challenges. Particularly those relate to cases related to public interest, where the lawsuit is brought in public interest or citizen suits. The expansion of standing has also been promoted through regional treaties. There is a very significant body of work under the Aarhus Convention, including a number of findings of the Convention's Compliance Committee that address this issue. And more recently, the regional Escazú Agreement included a specific obligation in the Treaty of the Text under Article 3 to provide for broad active legal standing in defense of the environment in accordance with the domestic legislation. There is, however, still a lot of work to be done, and so we very much welcome the guideline of Special Rapporteur that promotes this approach at the national level. The other issue that I wanted to address is related to guideline 7, and that relates to the enabling environment. In that guideline, the Special Rapporteur provides the states should guarantee an enabling environment to victims and environmental defenders free from threats, violence, and harassment. We've been looking at this issue for quite a few years now. And this is a very, very primary reminder of the importance that defenders and activists play in promoting environmental rule of law and ultimately protecting the environment. Threats to environmental defenders are increasing in intensity and frequency. That is what we found in our first report in 2019, and also continuously keep finding it, including in the 2023 report. These include intimidation, these include killings, these include assault, criminalization of activity, and defamation, and many other tools. Attacks on environmental defenders are often intended to have a chilling effect on those that try to advance environmental rule of law. Our report estimates that between 2012 and 2021, at least 1,733 environmental defenders in 61 countries were murdered. That is an average of killing one person every 2 days. So that's staggering numbers. In 2021 alone, 200 environmental defenders were killed globally. In many instances, these killings those who were killed were seeking to protect specific systems or were connected particularly to defending the interests and rights of indigenous peoples. Explicit legal protections for environmental defenders reinforce the rights to participate and demonstrate in defense of the environment. 25% of countries, we estimate around 48 out of 193, have enacted specific protections for environmental defenders, either through domestic law or through ratification of international treaties like the Escazú Agreement. In some cases, domestic laws provide for registration of certain environmental organizations that allows them a specific status and allows them to seek specific defense measures, and as well as redress. However, these laws are very important, but they may not be necessarily sufficient in themselves because they are very often not continuously enforced. Of the 10 countries where we found some of the environmental defenders that were killed, 10 of those countries actually have laws specifically addressing this issue. So the availability of legislation in itself is not sufficient. In addition to passing legislation, there is a lot of work still to be done, particularly in training local authorities, in training enforcement agencies, and even private security companies that often support developers, and having that training and interaction is very important. There's also extremely big role for the courts to play in ensuring that there is enforcement and prosecuting offense against environmental defenders. And then the last point that I wanted to make is on specialized tribunals and training for judges. The thing that this is really, really close to our hearts in Geneva, and this relates to guidelines 12 and 13 in the report. As we all know, environmental matters often involve very technical, highly technical issues, and specialized knowledge is required. And it's very often that proponents of projects often have that specialized knowledge way more than anybody else involved in the lawsuit, including the government and judges. So it is really important that there is specialized knowledge available to the judiciary, and it's available to all parties for that matter. And it is critical the judges have specific education and specific resources available to them in order to hear environmental cases. Their environmental tribunals, if they are established, will have several benefits. One of those benefits is that they can address matters more quickly, and they can also reach better decisions in environmental cases. They also can prioritize those cases because general courts are often very overloaded. The judges in those tribunals have specific training that allows them to better understand some of the technical issues. And they also have more experience with this as time evolves. There has been an increase in the number of such specialized tribunals and at a kind of a steady pace in recent years. We now counted 2,116 of such tribunals in 67 countries from 2021. And they take various forms, including things like special courts, green benches within the courts, with judges specifically trained in environmental law, or kind of amalgamation of different approaches. There are, however, also challenges, particularly arising from the lack of government and stakeholder support, competing needs, limited information technology, and the lack of enforcement. And those can lead to flawed appointment processes, failure to appoint or replace, failure of quorum within the courts, and where there is a lack of enforcement of the adjudication, plaintiffs are also reluctant to bring cases. So you can have a tribunal, but if it doesn't have cases, that is a problem. So it is an important issue to address, and it's also important to ensure that judges, whether in specialized tribunals or in general courts, have adequate access to training in environmental law. And as of 2020, at least 39 countries have judicial training institutes that included in their training programs specific training on environmental law for judges. And we UNEP very strongly promote this. We've been cooperating since 1996 with our fellow UN agencies, not just UNECE, who's present here, under the Aarhus Convention, but also with the judicial networks, such as the Global Institute, Judicial Institute for the Environment, and the European Union Forum of Judges for the Environment, to provide the training. But there's so much more of that needed, especially at the national and the sub-national level in local and regional courts. So a big welcome to this recommendation and the guideline in the Special Rapporteur's report. I will stop here. Thank you so much, and I'm very happy to answer any questions.
Thank you, Ms. Rochakova. Our next panelist is Analia Suarez-Franco, the Secretary General of FIAM International. We will reflect on the Special Rapporteur report from the lens of cases of affected communities that her organization supports. Ms. Suarez will also highlight some elements helpful for advancing corporate accountability and human rights, including the legally binding instrument on transnational corporations that has already been referred to in various side events to this session of the Council. Ms. Suarez, you have the floor.
Thank you very much, Diana, and also all my panelist colleagues and the participants. I would like to begin really thanking Marcos for this very timely report. I think we have, of course, all the standards you mentioned, and it's very important, but the situation on the field is really concerning. We get every month different denounces, not only from the affected communities, but also from the social movements that were with them. Some years ago, it was mainly on the communities on the field and peasants, indigenous peoples who are extremely exposed, but nowadays every one of us is exposed. If you see, I don't think there is a family that is not affected by sicknesses like cancer and other brain diseases, and in many cases that may be connected, most probably to the contamination of the planet that you have announced. And in this sense, well, we have to use all the existing corpus juris that we have. We also need this kind of reports that put the lens on the new challenges and how states can be guided in confronting them. And this is part of building international human rights law, which should be evolving according to the evolution of societies. And in this sense, the guidelines are really a new step that also contributes to different negotiations that are going on. Therefore, I would like to connect this report, not only the guidelines, but all what you identify with some cases my organization and other movements have been working with to show the pertinence of the recommendations and guidelines. And then I would also like to highlight some elements that could strengthen the negotiation of the TNC treaty process. So the three cases I want to mention here are first a case in Sri Lanka. We have, FIAN Sri Lanka has accompanied a group of peasants that have been affected by unknown chronic kidney diseases. These people used to be farmers, used to live between the pesticides that were sold to them, and now they depend on dialysis, and they have to go 2-3 times a week to treatment. The second case is a case in Honduras when we are working on climate change with fisher's women, but we also identified that all the toxics coming from the agro industry are affecting their lives. So this is a case where you can see the triple planetary crisis really destroying the environment and the people. And the third case is a case in Ecuador, the case Las Garzas, where a banana company has blocked the access to water, but also is spreading pesticides that are affecting the people. And I bring these three cases because Marcus has been informed about them, or even speaking to the affected people, and especially women, so they are very pertinent. And in these cases, I would like to highlight some elements from the report that are very relevant. The first is the latency of the period latency of the pesticides. In many cases, like in the kidney diseases, the people on the beginning never noted that they were getting intoxicated. And some legal systems begin counting the time that you have to be able to claim, which we call statutes of limitations in law, when the act is committed, but not necessarily when the people begin to realize that they are suffering the damage in their health. So this recommendation of the report on beginning to count when the harm is perceived by the affected people, what we call in law the victims, is very relevant to ensure that people have access to justice. The second one is the issue of the burden of proof. In the three cases I mentioned, normally when people go to speak to their authorities or go to courts, the first thing that they say is, sorry, we cannot decide on your case because you cannot prove that this toxic substance is the one that caused the harm that you are suffering, especially to your health. And these recommendations of the report to reverse the burden of proof or use the dynamic burden of proof, which means that the court should really identify which is the part in the judicial procedure that is able to contribute with the proof, is extremely relevant to ensure equality of arms or a balance in the process that ensure that people can access to justice and effective remedy. It's not only about going to the courts, but it's really getting all the set of remedies that Marcus very well referred. And maybe the other thing that I want to say is that in many cases, the communities do not have the documentation available. And when this is the case and they do not have the access to science, then the process in many countries may be finished. The recommendations in the report clearly say that judges should be able to request the scientific proof, and the scientific proof can come from experts, from epidemiology studies, but also from the citizen science, which means the knowledge that the normal people have. And I also have here the legal standing, and I would like to focus especially on the situation of women, where in many cases women cannot go to the courts because they have to care more for the sick people that these hazardous substances made sick. So in order to ensure that women can go to courts, there should be, for example, the possibility for them to be represented by others like NGOs, but also other very gender responsive mechanisms that are mentioned in the report. And finally, also to make the connection to the issue of future generations. We know that in some cases, the pesticides and other hazardous substances are not producing the visible impact now, but it may be for the future generations. And of course, if the statutes of limitations are too short or limited, we may not be able to ensure that people in the future do not suffer the consequences. And therefore, it's important to have the possibility of representation of these generations that may be in danger applying the precautionary process. Since time is short, maybe in the questions and answers, I can go more into the treaty process, but I would like to say that all the evidence that you bring in the report, including not only the binding instruments that are mentioned, but also the jurisprudence that is evolving, ratify many of the elements that civil society is asking in the TNC treaty process, like the reversal of the burden of proof, not abuse of the foreign non-convenience, the extraterritorial obligations of the states for companies based in their territories. But it also brings new elements that are relevant. One of you mentioned, Mariana, is the issue of the enabling environment for the human rights defenders, and we know that the SLAPs, the strategic litigation against public participation, is big, not only in the judicial, but before. And other elements are, for example, the lack of specialized judges. This is not now in the TNC treaty, and other elements that I can highlight later. So I think this is a very timely report that will help all the civil society and states that really mean advancing corporate accountability and human rights for the negotiations to come in October. Thank you very much.
Thank you very much, Ms. Lawrence. Our last discussant before we open the floor for questions is Marco Keiner, the Director of the Environment Division of the UN Economic Commission for Europe, that hosts the Secretariat of various important environmental agreements, including the Aarhus Convention on access to information, public participation in decision-making, and access to justice in environmental matters. Mr. Keiner will share with us measures to promote effective access to justice in toxic cases based on experience under the Aarhus Convention. Mr. Keiner.
Thank you, Diana. Esteemed Special Rapporteur, distinguished delegates, ladies and gentlemen, good afternoon. It gives me great pleasure to join this panel today as we discuss the critical topic on justice within toxic cases. As we have heard this afternoon already, toxic pollution puts our lives at risk, be it at the global scale, in our neighborhoods, or as local pollution hotspots. Moreover, pollution and waste is one of the core elements of the triple planetary crisis, as already said by the Special Rapporteur. Today's discussion on the growing global challenge of toxic pollution and the Special Rapporteur's report are very timely, because the topic has severe human rights implications. As toxic pollution continues to rise globally, communities, especially people in vulnerable situations, face serious health impacts, as we have also heard with some concrete examples, including cancer, neurological damage, and reproductive harm. Yet those people and communities that are most impacted often struggle to access justice, due to legal, financial, procedural, and other barriers. The United Nations Economic Commission for Europe, UNECE, is privileged to service a number of policy and legal instruments that promote access to justice in cases also involving toxics. Let me give some example. For one example is the environmental performance reviews. These advise governments on improving public participation and removing barriers to legal recourse. Treaties such as the Industrial Accidents Convention and the Protocol on Water and Health ensure that affected individuals have access to information, decision-making processes, and legal remedies. These frameworks help to promote accountability and ensure that impacted communities can seek justice and uphold their rights to a healthy and sustainable environment. Among the legal instruments, as mentioned by Diana and Mariana already, the Aarhus Convention, with its full name Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, with its protocol on pollutant release and transfer registers, these two instruments play a unique role in advancing access to justice in toxics context, in particular through the Convention's task force on access to justice. And maybe you know that both treaties are open for accession by any UN member state. The treaties uphold the right to request a legal review to ensure environmental laws are followed and human rights are respected. More specifically, they enable individuals or legal entities to challenge information refusals or legality of decisions, acts and omissions that are related to hazardous chemicals and waste management. Public access to such review procedures should offer fair and effective solutions, including urgent actions to stop harm when needed. Review procedures should be handled quickly, fairly, and without being too expensive. The accessibility to procedures is especially meaningful for people and communities that are already experiencing poverty, discrimination, and systemic marginalization, since the evidence shows that the burden of contamination could fall disproportionately on them. The Special Rapporteur's report highlights the many challenges people are facing when trying to take legal action. In response to the call for this valuable report, the chair of the Aarhus Convention's Task Force on Access to Justice submitted his input on practical measures, which I would like to bring to your attention, and you have it on the slide. Establish a clear legislative and practical regulatory framework on chemicals, including introducing access to justice provisions. Promote the effective enforcement of legalization relating to sound management of chemicals and wastes. Establish fast-track procedures for those affected by exposures to toxics to apply for interim relief and to request immediate suspension of pollution until scientific and other evidence is fully analyzed and the case is heard. Promote multi-stakeholder dialogues to address existing challenges in bringing these types of cases. Take additional measures to remove specific barriers faced by groups in vulnerable situations, such as children, youth, persons with disabilities, and to establish assistance mechanisms to support them. Strengthen awareness raising, capacity building, specialization, and international cooperation among legal professionals. promote information to the public on access to administrative and judicial review procedures and on decisions of courts and other independent review bodies. Consider establishing independent bodies providing technical expertise in environmental cases, improving access of legal professionals to independent environmental expertise and scientific knowledge. Strengthen environmental monitoring, assessment of chemicals exposure, and open source scientific knowledge exchange. Promote the mutual acceptance of data and chemicals assessment in different proceedings, such as civil, administrative, and criminal, regarding the same chemicals. Promote cross-border cooperation between jurisdictions on cases of transboundary pollution or damage. Promote the establishment of multidisciplinary specialized teams and joint investigation teams for environmental cases. Promote specific remedies that could be available in environmental cases. Continue trends in chemicals-related litigation. I think that's a really strong catalog of possible measures. So let me conclude, ladies and gentlemen. The work under the Aarhus Convention and its protocol offers a space where governments, experts, and the public regularly share experiences on how to make justice systems work better for environmental cases. This work is particularly timely in view of achieving the Sustainable Development Goal Target 16.3, which is related to access to justice along with other relevant goals, and we at UNEC stand ready to cooperate with the Special Rapporteur on promoting international standards in this area. We at ECE are committed to furthering synergies and collaboration across organizations, governments, and others to support access to justice. In this respect, I appreciate the opportunity to share our experiences with so many highly esteemed partners today. Thank you for your attention.
Thank you, Mr. Kalmer. Now that we have heard the key messages from the Special Rapporteur and how timely this report is, and the links also with ongoing processes and discussions and strugglings, we have time to engage with the panel and with the Special Rapporteur. So I'm turning now to the room. Somebody wants to ask a question or make a reflection on what was shared, please announce yourself. I see that our justice has asked for the floor, so please introduce yourself. Thank you.
Well, thank you very much, Isidore from Earth Justice. So I'm wondering if states who are in the room wanted to take the floor before the usual order of discussions. But first of all, I'd like to thank the organizers for this session, and also really thank the Special Rapporteur for his last report to the Council and to focus on this issue of access to justice. I think what really struck me in reading the report is how much, and we saw that already in previous reports, but here it's particularly obvious that we are with the access of justice as one of the key articulation between the field of toxics and the field of human rights. We know how much this mandate had. It took some time, and it was created in 1995. So it is the oldest human rights environment mandate in the Council. And it took some time for this issue to be correctly considered as being really a human rights issue. We see clearly with this report how much it is and what the work which is being done here can bring to this whole field. You've mentioned, Mr. Special Rapporteur, the human rights standards, but also that are particularly relevant for this type of work. And we see how much they have to be very often interpreted in different ways in the new light of the challenges linked to toxics. And what we heard from Mrs. Suarez and Mrs. Bortakova are very relevant to these elements. There is a thinking within the field of human rights that needs to move forward in order to tackle these issues correctly, precisely to protect human rights. A very classical approach is not enough and actually fuels human rights violation. So your guidelines, perhaps we're going to call now the Orellana guidelines, but the 24 guidelines are really extremely useful. They're very practical, very well focused, an excellent instrument. And I have two questions to ask you. The first one relates to the recent development we went through with the advisory opinion of the International Court of Justice. Now, I know everybody's going to say, oh, but wait a minute, this is from climate change. Yes, but in the judgment itself, they do make references to the fact that there has been a huge jurisprudence in the field of pollution, that it's clear, and that precisely some of the arguments which are used in the field of climate change to say, oh, this is very different, cannot be used like that, are not relevant. And I was wondering if, when you crafted this or in the implementation of these 24 guidelines, you saw some echoes of what the ICJ has said, because what the ICJ has said decidedly goes beyond just the question of climate change. And finally, because your mandate, it's your last report, but it's not the end of your mandate. We still have the pleasure to be working with you in the coming months. And as we heard, we're soon going to have the 8th meeting of the parties to the Aarhus Convention, and was wondering if you intend to present this in the meeting of the parties, because this is definitely an element and an instrument very relevant for the implementation of the Aarhus Convention, as well as for the Escazú Agreement. Thank you very much.
Thank you, Mr. Lador. I see that Panama has also raised a flag, so please.
Thank you. Thank you. I would like to thank the Special Rapporteur for convening this meeting, as well as the Côte d'Ivoire Permanent Mission and the GEN. The report highlights challenges that are very relevant to many countries, including Panama. In our case, issues such as exposure to our chemicals in rural areas, the management of these harmful residues, and the need of a stronger safeguard in waste management illustrate how environmental harm can affect both human rights and ecosystems. For example, river in Central Azuero, where pollution hotspots were reported in the La Villa River and Estibaná, affecting almost 300,000 people. Another case is the pollution of rivers Tijarones, Ixilibre, near Viración Lake, due to the organic and industrial waste, which has reduced the oxygen in the water. We particularly appreciate the emphasis placed on ensuring that remedies are not limited to compensation, but also include prevention, remediation, and guarantee of no repetition. We appreciate the effort of the Special Rapporteur to develop practical guidelines that aim to overcome these barriers and to strengthen accountability, prevention, and remedy. This approach is essential to protect vulnerable communities, including indigenous people, who often face the greatest risk. Panama values the contribution of this report and look forward to continued dialogue and cooperation. And I would like to thank again the organizers and the panelists for your precious contribution. Thank you.
Thank you very much, Panama. May I suggest, considering the time schedule, Mr. Special Rapporteur, that inspired by these comments and by the questions, you incorporate the answers in your concluding remarks?
Thank you.
Thank you, Diana, and thank you very much for the questions. And so on the encouragement that Earth Justice makes to the field of international human rights law to move forward and apply its principles and standards to the current situation involving toxics and toxic pollution. There's an example that I wish to point to, and this relates to something that Ana Maria also mentioned in regards to limitations, and now the case that was highlighted by Panama involving pollution affecting 300,000 people. So in many cases, there may be a victim or a family or a community, but in many others, it may be a whole ecosystem, even a generation that may be affected. And so when it comes to human rights tools that have been developed in the past, such as remedies for gross violations of human rights, It may well be the case that given the impacts of toxic pollution, the widespread suffering, the impacts on whole ecosystems, that the point of relieving statute of limitations, so making them inapplicable in situations of gross violations of human rights, is relevant for violations involving toxic contamination. So that's a first point that I thought I'd highlight. The second point on the question about the relevance of the advisory opinion of the International Court of Justice on the obligations of states in the context of climate change. That advisory opinion, I must say, was released after this report was finalized, and so the report does not include or reflect that opinion. There is an element of the advisory opinion of the Inter-American Court of Human Rights in the context of the climate emergency that did make it in with the indulgence of the UN editors, that speaks to the importance in guideline 20 of remedies being based on best available science and local, traditional, and indigenous knowledge. So I wish to highlight that point that is made in the advisory opinion of the Inter-American Court of Human Rights. Now, going to more specifically to your question, there are several implications of the ICJ's opinion. Let's recall the ICJ being the chief judicial organ of the United Nations, so the weight that this opinion carries. First of all, as Yves Lador, you mentioned, well, the opinion is focused on climate change obligations or international obligations pertaining to climate change. It does not stop there. The implications are broader and concern environmental protection more widely. And an example of that is the discussion on the right to a clean, healthy, and sustainable environment in that opinion. Let's recall that in the proceedings, there was much discussion of whether this right had attained the status of customary law. And the court, in a way, quite astutely, I would say, sidestepped that discussion and said, well, this right is essential and important to the realization of other internationally protected rights, such as the right to life and others. And so for a member state that has international obligations of respect, protection, guarantee of the right to life, by implication, the right to a healthy environment is part of the corpus of international law applicable to that state. And that has implications not only for climate change, but definitely for toxics related issues. On the question of attending the 8th meeting of the parties of the Aarhus Convention, I want to thank the input by the Task Force of Access to Justice of that convention. I had the opportunity to present to the Access to Justice Task Force as well. I doubt that I'll have the chance to join the meeting of the parties, but my wife is here with me, so I can ask permission already. But given the time, let me conclude by thanking, well, let me make an overarching statement. I don't think we will overcome the gravity of the toxification of our planet one case at a time. There are various levels of action that are needed. And for example, my first report to the Council was on the right to science and the need to bridge the gap that exists between the current level of knowledge and the response measures. So prevention, a human rights-based approach to environmental laws, to multilateral environmental agreements. Much could be said about that, but accountability is a key pillar because impunity aggravates environmental injustices. Impunity undermines legal systems or our ability to be civil and build a civilization on institutions. And so with that, I want to thank, first of all, Côte d'Ivoire for taking the penmanship of this important resolution on toxics and human rights, and the Geneva Environment Network for partnering with the mandate throughout the years. Thank you so much.
Thank you very much, Mrs. Rapporteur. It's already 1:02 and the next organizers are waiting outside. There will be, if the schedule allows, there will be events tomorrow organized here at the Palais to unpack further This report and other reports of the special statement. Thank you very much. And apologies for the
Siempre corriendo.